Hello, Attorney General.
Good morning, AG. Good morning, Johanna.
Hi, Christopher. Good to hear everyone's voice. I'm going to turn it on.
Good morning, Johanna. Good morning, Christopher.
Thank you so much for being here. I know it's busy for everybody.
Hey, Johanna, I'm getting a message when I try to turn on my camera. It says the host has stopped it. I don't know what that means.
Okay, let me.
Yeah, I'm getting the same message too.
Okay, Chris, I'm going to also make you a co-host. Just so you have the abilities. And then let me.
Good day, Rose. Good to see you.
Oh, thank you very much, Christopher. Good to see you as well.
This is weird. Oh, okay, there's Chris. Maybe I just have to make you all co-hosts so that you can show your spaces.
Have many people registered for the webinar?
75.
Oh, wow.
Yeah.
Great.
And then, like I said, we will also have this edited from our team and then be able to put it on to YouTube so that it can be bits and pieces of the important information can be shared.
Fantastic.
Yes. Okay. Attorney General, is your...
Let me try and see.
Yeah, let's see.
Okay, I think it's working.
Yay, yes.
Yeah.
Beautiful.
How is everyone?
Hello.
Joanna,
Hi, Boda.
I'm trying to start my video. Oh, okay, it's fine now. I was getting a message. Yeah.
No, yeah, we all got it. So I just made everybody co-host. Okay,
cool.
That should cover it. So for the question and answer, I've done it before where I can either just send you the questions into the Zoom private chat, or if you want me just to facilitate the Q&A, if that's too much, I can also do that. What would you prefer, Autumn?
I'm happy to do either. I mean, I guess you mean if you send me the questions in the Q&A, I'd sort of like read them and direct them to the panelists.
Yeah, like, so it would be, I will have the question and answers tab and can, follow along with that and then just send you the questions in order so that you can continue just moderating through the Q&A. Or, I've had some folks that prefer that I just WhatsApp it to you if it's too much within Zoom. So it's just whatever works best for you.
I think in Zoom should be fine. Yeah.
Okay, great.
And Mamadou is going to be on the panel too, is that
Yes,
right?
he said he's staying on, which is wonderful.
Okay, cool. And I mean, I guess he'll join soon, but do you know what he'll specifically be focusing on?
Yeah, so he's going to go into the procedure. So he'll be the first after we hear from the AG as the intro, he'll go into the broad strokes of the really and the nitty gritty of the procedural stuff. Then it'll go over to you, and then we'll open it up to the panel. And, you know, Rose will talk Tonga's experience. Chris can give some stuff. And then I think Mamadou also being on the panel can provide insights to questions. And then I think especially having him for the question and answer,
Okay.
I anticipate we'll have a fair bit of that. And
Okay,
I've also
so
got some questions written down in case that doesn't happen, but
okay, cool. And sorry, just to clarify, so for the panel, Mamadou won't be giving sort of like separate remarks. He'll just be on the panel too.
I would imagine, yeah, he's just on the
Okay.
panel, but you know, feel free to open it up and, you know, depending on how conversation goes as well. I imagine, you know, if there's a bit of free flow, we can let happen.
Yeah, sounds good.
Great.
And then, sorry, one last question is, Rose, will you be going first and then Chris, or other way?
Chris, then Rose.
Okay, cool. And then, sorry, one more question for
Yep.
Rose, which is, Rose, I just want to make sure I have your last name pronunciation correct. Is it, oh, go ahead. Maybe
So
you-
it's Kautoke.
Okay, cool. That's what I thought, but
Yeah,
wanted to make
okay.
sure.
Thanks.
Yes, message Mamadou. Did you all receive separate emails as host and panelists?
I did, yes.
Yeah, early this morning. Okay, just making sure. I'm sending the link directly to him as well. Is there any issues? Our CRGA, our governing body, is meeting at the end of the month, so we don't have IT for this. So I'm playing many different hats today, and we'll get started soon once we have him. And then maybe when we'll all just have our cameras off for Attorney General and Mamadou, and then just back on when it's the panel. That way, the person who's speaking is always the main and front and center person. And then, what is the best thing? Attorney General, would you like for SPC to introduce you, or would you just like to start right off and welcome folks?
I don't know. I'm good with either of them. Yeah. I assume because of this, you know, people have seen me or met me. Or,
People have seen you
know,
a lot, yes.
Either way.
I'm
but,
happy. I'm happy for you to do the welcome, whatever you feel is most appropriate.
Yeah.
You're a celebrity in and of yourself, so I think, yeah, no introductions are necessary.
Yeah, but it's all right. No problem.
Okay, so we'll have your face up front and center in about 5, and then hopefully, let me just message Mamadou directly as well and make sure he's not having connection issues.
Sorry, Joanna, one more question just quickly. After
Yes.
I give my remarks, I guess we'll transition to the panel, which I am moderating. So shall I just sort of,
Yeah, I
Yeah.
think that'll make sense. I mean, I that way we're not breaking it up and
Yeah.
you're essentially the MC like person anyway.
okay, sounds good.
So yeah, I will be off camera and in the background until I am needed.
Okay, sounds good.
So that we can have things move forward smoothly. So it will start with AG's face will all be off. And then maybe who is introducing Mamadou? You have his bio, Autumn, or not? I do have it if you need it.
I mean, I have his bio, not one that he sent me, but I know
Yeah,
who he is and like,
right.
yeah. Yeah.
So yeah, it's just up to you. I mean, I can come in and introduce him, or if you'd like to. It's I think up to you. It's fine for you to be the transition person since you'll be the main moderator.
I don't mind, whatever you prefer.
Okay, yeah. So after the Attorney General finishes his beginning opening welcome remarks, then you can come on camera and introduce Mamadou. Hopefully he's joining soon.
Okay.
If he's having issues connecting, then we'll just go from AG to your remarks
Mhm.
to him,
Yeah.
or if not, then panel, then him. We'll see what goes, but I'll keep everybody. The message board here is just hosts and panelists.
Okay, that sounds good.
Okay, I see Autumn also, Mamadou just sent you a short brief bio. Good. I'm just getting some messages from participants that they're having a little trouble connecting. So if we can just hold off for a couple of minutes before starting, I'm gonna get that fixed. Okay, so if we can have panelists go off camera, except for Attorney General, I will count the Attorney General in to begin our webinar. Just gonna, great. There we go. I'm gonna go on mute and you
So
can
we start.
begin. Yes, you can begin whenever you're ready.
All right, thank you. Well, firstly, everyone, I would like to welcome you all to this webinar. And at the outset, I would like to say my appreciation and thank you for the Pacific Community SPC for putting together this series of webinars. Thank you. We appreciate the assistance you are offering to everybody who is involved, who are involved in this ICJ initiative. Now, at the outset, webinar series are intended to be a practical resource for states working on their submissions to the ICJ for the advisory opinion on climate change. Our Vanuatu's climate diplomacy and legal team most appreciative to have the opportunity to have access to additional capacity building resources and hope that many others will benefit from them as well. As most of you will already know, last year Vanuatu's government and a small group of core group member countries started advocating for a UNGA resolution requesting the ICJ to provide an advisory opinion on the obligations of states in relation to climate change. It was a historical event for Vanuatu to see the resolution endorsed by the UNGA, by consensus, of course, that was early this year. Now, this came about because a young group of Pacific Island students at the University of the South Pacific Law School, based in Port Vila, decided to take up the responsibility of fighting climate change and convince Vanuatu government to take up the cause, to champion the cause. We now know very well that this wasn't just their cause. The climate emergency impacts everybody. And from the Vanuatu government side, this was an opportunity to take another road, a new one. And we had been participating and advocating for greater commitments at COP and other international forums for decades, negotiating with polluters in good faith. But we saw the impacts of this was not sufficient to get us to avoid the catastrophic disasters, let alone address and remedy the environment and human impacts that we in Vanuatu and our brothers and sisters around our region have already experienced. In today's webinar session, we will hear from each on the ICJ advisory opinion process, the key substantive and strategic aspects of the legal questions put before the court, and guidance on how to frame argument specific to our region. Like many nations in our region, this is the first time Vanuatu is participating in the ICJ proceedings. There is much to learn and even more to do. For those of you joining us on this road, we hope that you will all find the information shared today informative and motivating to ensure that you can contribute to your nation or region submissions process in a way that will have a positive impact on generations to come. And once again, I thank you and welcome to our webinar. Thank you.
Hi, everyone. Thank you so much, Attorney General, for those remarks. My name is Autumn Bordner, and I'm an attorney with Blue Ocean Law, which is the legal team representing Vanuatu in this initiative. I'll also be moderating this webinar and also providing some remarks about the sort of substantive, legal, and strategic rationales behind the formulation of the question. But before I do that, I wanted to turn the floor over to Professor Mamadou Habi, who is Associate Professor of International Law at Leiden University. He's also a former legal officer and special assistant to the president of the ICJ and a member of the New York Bar. And he'll be providing some remarks about sort of the general overview of what an advisory opinion is, their use, their importance, and the procedure around the advisory opinion process. So Mamadou, the floor is yours.
Yes, good morning, everyone. I'm told that the organizer has switched off my camera. Is it okay that I start without the camera? Can you hear me?
We can hear you, and I just turned on your camera. If you turn it on, apologies.
Okay, no problem. No problem. Yes. Perfect. So, good morning, everyone. It's early in the morning here in the Netherlands. I have been tasked to provide a general introduction to advisory opinion. I would say as a starting point that we have to place ourselves in 1945. 1945, we are just getting out of the Second World War, and the drafter of the UN charters UN Charter are trying to establish a system for the maintenance of global peace. Of course, one of the first things that they do is to prohibit the use of force. But if you prohibit the use of force, you also need to think about ways for states to solve their dispute. And for that purpose, they decide to establish a permanent international judicial body, which is called the ICJ, the International Court of Justice. So the International Court of Justice was established as a forum where states would be allowed to come to solve their disputes and find ways as to, as a way not to engage in conflict or in war. But the UN also realized, the drafters of the UN Charter also realized that in the working of the UN, there might arise legal issues where the advice of a court or tribunal would be necessary. So what are those kind of legal issues that where the international law and international opinion might be regarded? For instance, the Secretary General of the United Nations serves as a depository to many international treaties. And there were a moment, let's say, for instance, the Genocide Convention, where when states were depositing their instrument of ratification to the Genocide Convention, they will introduce reservation to some key provisions of the treaty. And the Secretary General realized that if he was to allow all these reservations, the treaty would lose its significance. It will just be a treaty which contains a lot of reservation, and therefore that would diminish the value of the treaty. Where could the Secretary General go in order to have a finding as to the validity of the reservations that states were making to the Genocide Convention? The only way where it could go, because it's not a dispute in a literal sense, so you cannot start contentious proceeding, but the only way where the Secretary General could go was towards the General Assembly, asking the General Assembly to ask from the Court of the United Nations what are the conditions under international law to make reservation to the Genocide Convention. So this was in 1949. And from that moment on, there were a lot of advisory opinion that were requested in order to assist the General Assembly, the United Nations as a whole, in its functioning by clarifying rules of laws, the rules of law that are applicable. So you had this 1949 advisory opinion. You also had the certain expenses of the United Nations advisory opinion, the advisory opinion on how to terminate a treaty between the World Health Organization and Egypt, etc. So this is one line of advisory opinion that were requested from the International Court of Justice. They serve really to help the organization to work, to function appropriately by providing it legal advice from the international law perspective by its own court, which is the ICJ. Next type of advisory opinions are those advisory opinions which are not necessarily defined by the fact that they respond to a concrete legal issue relating to the functioning of the UN as such. But these are advisory opinions which raise fundamental questions for the entire membership of the UN. So those advisory opinions raise issues of international law that affect all UN members. And state individually cannot ask those advisory opinions from the court. What has happened was that it was the General Assembly and specialized agencies were also given the power to request this kind of advisory opinion that will enlighten the entire international community of states on what international law says about a given issue. This kind of advisory opinion started, the first one that I can remember is the Western Sahara advisory opinion on whether Western Sahara people have a right to self-determination. It was useful for the UNGA as such, but it concerned the entire community because Western Sahara and Palestine are one of the few territories where people did not yet exercise their right to self-determination. Another example I could think of is the advisory opinion on the legality of the use or threats of nuclear weapons. You understand that the large majority of the world does not have nuclear weapons, and they are interested in having these weapons prohibited. But negotiations have not been very productive, and therefore requesting an advisory opinion on the legality of the use or threat of use of nuclear weapon was of great significance. The last one that I want to mention today, of course, you have the Chagos advisory opinion, which also concerns self-determination, is the current advisory opinion that we have before the court on the obligation of states for with respect to climate change. So you see how advisory opinions serve not only to contribute to the work of the organization, but also to provide legal guidance to the entire international community on issues of significance to all its members. But because the advisory opinion has such a wide reach in the sense that it will affect the entire community, the procedure for delivering the advisory opinion provides for the opportunity of all state members to be able to express their legal views as to the questions that are asked to the General Assembly, to the court. So states, all states of the United Nations have the right to appear before the ICJ and give their views on the legal issues, guide the court in settling, in shaping the problems and the legal solutions that have been asked to it from, in that case, in our case, the General Assembly. International organizations also have this power, but international organization power is a little bit curtailed. Their power to be able to submit opinions or guidance to the information to the court is dependent on the fact that the court should assess that this information would be useful for its decision. And in that respect, a distinction, you have a nuance between the statute of the court and what is happening in practice. In the statute of the court, it is the court that has to identify the organizations that are capable of rendering an advisory, useful information to the court. So it is to the court to determine what are the organizations that are capable of providing it with useful information. In practice, though, it is not the court that does so. It is state that approach the court or the organization that approach the court in order to tell the court, look, I have relevant information to give to you with respect to the two questions that are asked by the General Assembly. They explain briefly why they believe that they have this information, and the court takes a decision authorizing them, therefore, to provide written submissions and presenting oral argument before the court when the case arises. In the advisory opinion, and here I'm concluding, that has been submitted, the request that has been submitted by the UNGA, in that advisory opinion, there was a first date which was fixed in September for state and international organizations that have been authorized to submit opinions to the court. The first deadline was, I think, in September, but thanks to Vanuatu, which managed to convince the court that this deadline was too short, the court has adopted an order extending the deadline for the written submission to 22 January 2024. We might believe that we still have a little bit of time, but it's better that we get started because this is really the opportunity for all states and for international organizations that are authorized by the court to express their legal views. This decision of the court will remain in the legal system for at least the next 50 years. So we should not miss the opportunity to contribute to informing better the court, in guiding the court in shaping the legal issues, and in providing the answer which is the most conducive to protecting the global climate. So I would really encourage all of us that are working on this to do our best to guide the court in addressing these two decisions. Because even if the advisory opinion is not binding formally, the norms that the court will identify as being the obligation of states will be binding under customary international law. And therefore, their definition of the court as such will have great impact. I will stop here and I will pick up any question that may arise during the discussion. Thanks again for your attention.
Thanks so much, Mamadou, for those remarks. We all have learned a lot. I'll just go ahead and dive into my comments now before sort of opening it up to the broader panel. So I'll be talking about the sort of strategic and legal rationale underpinning the formulation of the legal question that's being put to the ICJ. So just before I get into the specifics, thinking about sort of the impetus behind the initiative and the question, you know, as you all are aware, sort of the main recognized international legal principles that have been used to manage climate change and climate action to date have been under the UNFCCC and the Paris Agreement. And while there's been progress there, it's really been inadequate. The climate action that has been taken to date has been inadequate to sort of achieve the level of emissions reductions, adaptation, and compensation necessary to sort of avert catastrophe, climate catastrophe. At the same time, it's clear that climate change is a issue that is other bodies of international law have something to say about. You know, it's clear, for instance, that climate change is a human rights issue, that climate impacts are already impinging on the right to self-determination of many peoples, that international environmental law obviously has something to say about climate change, but right now there's sort of a gap in terms of understanding about what specifically these well-settled principles of international law mean in the context of state action and state obligations with respect to climate change. There hasn't been a sort of authoritative statement about what these international law principles mean in this context. And that's sort of what the International Court of Justice, as the most authoritative international body with respect to questions of international law, can provide. It's a clarification of these existing well-settled international law principles applied to the context of climate change. So the court can provide us with an understanding, a clear understanding of what obligations states have under these international law principles, and what are the consequences if states violate those obligations and cause harm to other states and to vulnerable peoples. So with that in mind, I'll just quickly run through the specifics of the question, and I'm just going to share my screen so that hopefully everyone can see this, so that we can sort of follow along with the text. And as you all know, and as Mamadou just mentioned, the question was referred to the International Court of Justice in this context through a resolution from the United Nations General Assembly. So that resolution has two components, which are a preamble that sort of provide context to the question, and then the question itself. So I'll just briefly go through the preamble and highlight some key points there, and then focus primarily on the question itself. So this is the resolution. Again, just sort of some high-level things to note in the preamble of the resolution. First is that right from the outset, the preamble is mentioning relevant international law principles and sources that are outside of and beyond the UNFCCC. This is really emphasizing to the court that, this is a question that the entire corpus of international law needs to be drawn upon to answer. We can't just restrict ourselves to this obligations to negotiate in good faith under the UNFCCC. So just sort of listing a number of key principles there. Then the preamble does mention the UNFCCC and the Kyoto Protocol and the Paris Agreement, which are of course relevant. And importantly here, it's emphasizing, what I mentioned before, that there's this significant gap between what is required to keep our world safe and protect people from the impacts of climate change and what we're actually seeing in terms of action, and also emphasizing the equity and justice dimensions of the question, the fact that those least responsible are also most severely impacted, and that vulnerability is not necessarily an innate characteristic, but is also the product of historic injustices as well. And then just one paragraph to sort of spend a little bit of time on here is this one, which is discussing the scientific consensus on climate change. And this is paraphrasing statements from the Intergovernmental Panel on Climate Change Summaries for Policymakers, basically saying that, it's well settled, it's not up for debate that climate change is a product of anthropogenic greenhouse gas emissions, that adverse impacts are already being felt, and that they are being felt most keenly by those who are least responsible for the climate crisis, and that the window of time during which we can sort of prevent irreversible and catastrophic loss is rapidly closing as we approach biological tipping points like melting of ice sheets, after which the rate and intensity of climate change will increase dramatically. And these statements, basically the important point here is that these statements have been issued by the IPCC Summary for Policymakers, which means that they represent not only a scientific consensus, they've not only gone through this process of rigorous scientific review, by scientists from virtually all states, but they've also gone through this process of rigorous political review by representatives of all states who have to approve all of the statements that go into the summary for policymakers. So basically, these are settled facts, they're undisputed, and the court should not waste its time sort of getting enmeshed in a debate about the science of climate change. That's settled. What the court should really be focusing on are these legal questions, clarifying what these international legal principles mean with respect to state conduct that causes climate change and the harms to vulnerable states and peoples. So that's just something important to keep in mind, especially with submissions, to emphasize, court, don't worry about the science so much, just accept it as fact, like most of the countries in the world have done, and focus on these legal questions where we really need your expertise to clarify what is required. So yeah, that's basically what I wanted to emphasize from the preamble. Now we can move on to sort of the question itself, which has two main components. It has a chapeau paragraph, which sort of sets out relevant bodies of law that the court should look to, and then the actual question itself. So the chapeau paragraph here, basically, while the court is free to look to any international law principle that it wishes to answer this question, we're highlighting here in the chapeau paragraph some core relevant sources of law that at minimum is expected that the court will look to. So these include the Charter of the United Nations, which is a foundational international law document that also enshrines the right to self-determination. We also have the two key sort of international human rights treaties, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, which really sort of set out the core principles of human rights law and which most states have ratified. We do also have the UNFCCC and the Paris Agreement, which set forth rules governing sort of the conduct that's at issue here. So that's sort of conduct around mitigation of emissions, adaptation to climate change, climate finance, and compensation for loss and damage. Then also mentioned is the UN Convention on the Law of the Sea, which enshrines some relevant principles like prevention of marine pollution and protection of the marine environment from degradation. And then in addition to that, we also have some key principles of international customary law. And so this means that these are principles that regardless of whether they're enshrined in any particular treaty or whether states have ratified any particular treaty, these principles are binding. They exist separate and apart from just ratification in treaties, and they're binding on all states. So some important ones here are, for example, the duty of due diligence. And this is a principle that's really important here in the, because this principle basically establishes that states have to act with requisite care to ensure that their conduct does not harm other states. So it's sort of providing a standard. It would provide a standard against which state conduct can be evaluated to determine whether or not they're in compliance with their substantive treaty obligations. And because the duty of due diligence also has this preventative character, it's not only capturing concerns about harm that has already been caused, but also the responsibility of states to prevent harm in the future. So very important in terms of climate action. Also principles of international environmental law, like the principle of prevention of significant harm to the environment and the duty to protect and preserve the marine environment, both of which are clearly implicated in this case because climate change is having and already has had serious impacts on both the terrestrial and marine environment. So again, this paragraph is basically pointing the court to core international law principles that are relevant to the question of climate change and state obligations in the context of climate change. And then sort of moving on to the question itself, we're asking here, what are there are two prongs, and within these prongs are sort of three core components to the question, which should be treated as a whole. The question, in order to have a sufficient answer to the question, the court has to address all three of these prongs. And these are, what are the obligations of states under these various sources of international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations. And so this basically is asking, looking to these various sources of law, not only for the court to state what the obligations are, but to clarify the content of those obligations, the substantive content of those obligations. And then the second component of the question has arguably an even more important component of the question, which is, what are the legal consequences under these obligations for states that have caused significant harm to the climate system and other parts of the environment? So this is asking, if a state is out of compliance with its obligations and has caused harm, what are the consequences? In other words, what does that mean? What action does the state have to take to remedy this situation? So this is really important in terms of sort of achieving climate justice and advancing the needs of vulnerable states and peoples like island states that have already been harmed. What do the states that have caused that harm have to do? What do they owe, perhaps you could say, to the states and peoples that they've harmed? So that's sort of the formulation of the question, the overall formulation of the question. It's important, again, that the obligations aren't only defined, but the consequences of violations of those obligations are also fleshed out. Now, in terms of thinking about the type of state conduct at issue, this is also defined in the question. We define it as acts and omissions that have caused significant harm to the climate system and other parts of the environment. So acts and omissions, really, you can think about that as sort of an act, a positive act, like emitting greenhouse gases, and then omissions as failures to act. So failures to reduce greenhouse gas emissions or otherwise take required climate action. And this is not any level of emissions by any state. What we're talking about here is acts and omissions that rise to the level of causing significant harm to the climate system and other parts of the environment. So this doesn't necessarily capture, the negligible contribution that emissions from, for example, small island states have contributed. It's really talking about those level of emissions that have substantially contributed to the harm. And then another sort of important component of this formulation is the term have caused, which defines the temporal scope of the question. And the term captures past emissions, past that have caused at the time that this question is posed. But because the question is evaluated at whatever time that the conduct has been committed, that also means that it captures emissions in the present and in the future as well. And capturing all of these different temporal dimensions is really important. First, because past emissions are kind of key to capture in terms of advancing climate justice, because the harm that has already been felt by states and peoples and that is being felt right now is fully the product of past emissions. And those emissions have been primarily caused by a few wealthy developed nations who, moreover, knew about the negative impacts of climate change since at least the 1970s. So a question that was only forward-looking would not necessarily, or would actually fail to redress the harm that has already been perpetrated and that's being perpetrated right now. So having that past emissions is really important for climate justice. On the other hand, having present and future emissions considered is equally important in terms of encouraging more ambitious climate action in the future. Because if states understand that their levels of emissions or failure to reduce emissions in the future will bring them out of compliance with their obligations, they'll be more likely or influenced to bring those emissions under control and to take more ambitious climate action. So this temporal scope is something that's also really important to emphasize the need to address all of it, which is, in fact, how the question is formulated. So sort of concluding, hopefully, the last sort of dimension that I wanted to emphasize is the groups of interest that state conduct has caused harm to. So we're not in this question asking about obligations of states that have caused significant harm to the climate system generally, but we're asking about what are the legal consequences for those states that have caused significant harm to the climate system that have in particular impacted two groups. The first is states, including small island developing states, which are considered injured or especially affected or particularly vulnerable to the adverse effects of climate change. So this means first, states like small island developing states, which are included here, that have already experienced negative impacts, serious negative impacts from climate change. And then also particularly vulnerable states, which is a broader class of states, which basically is indicating, states of the global south whose geographic circumstances and level of development render them particularly vulnerable. So when we think about what are the consequences for states whose conduct has harmed other states, what we're really thinking about is sort of the law of state responsibility, which is codified in the International Law Commission's draft articles on state responsibility. And basically, although the specific implementation may vary slightly depending on the substantive law at issue, basically this means that if a state has violated a legal obligation and has therefore caused harm to another state, that state causing the harm has an obligation to cease the harmful conduct and to provide a remedy to the harmed state. So in this case, what that means is, cessation of the violation. That might be reducing greenhouse gas emissions or implementing domestic measures to bring the private emissions of actors within a state's jurisdiction under control. And then providing a remedy. Actually, the preamble gestures a little bit about the type of remedy that might be appropriate. It's talking about climate finance, providing capacity building, technology transfer, assisting with adaptation, providing compensation for loss and damage. So this is the type of remedy that we hope to nudge the court towards acknowledging. So that's sort of what is expected, or the impetus behind the drafting with respect to legal consequences for state action that has harmed other states. The other group of interest here are peoples and individuals of present and future generations affected by the adverse effects of climate change. And this is really getting at the human rights dimension of the question. So thinking about individual right holders in whatever class they may be, women, children, etc. And then the people's right really gets to this question about self-determination. What are the obligations that states have with respect to people's self-determination, upholding self-determination, and what action do they have to take to remedy their conduct that may have caused climate impacts impinging on that self-determination. And I am conscious of the time. That's pretty much all that I have, although I'm happy certainly to ask to answer questions during the Q&A. And now I'll open it up to our broader panel, who I can also introduce. I'll stop sharing my screen. So on to our panel, we have, in addition to Mamadou, who will be joining us for Q&A, we have Dr. Christopher Bartlett, who is the director of Vanuatu's Climate Diplomacy Program and is the lead negotiator on loss and damage for Vanuatu at the United Nations. Dr. Bartlett holds a PhD at James Cook University and has done a postdoc with the Nobel Prize laureate Elinor Ostrom. And then we also have Ms. Rose Kautoke, who is the Senior Crown Counsel and head of the Legal Advice and International Law Division for Tonga. And she's also a member of the Tonga core team working on Tonga's ICJ AO submission. So I'll turn it over to Dr. Bartlett first, who will focus on ICJ narratives that are particularly relevant to these contexts, particularly around loss and damage and the work of the UNFCCC to establish loss and damage fund and funding arrangements. So the floor is yours.
Thank you very much, Autumn, and thanks for all of you for joining this webinar. Look, the situation is existential. In Vanuatu, it's existential in the Pacific and around the world. We must keep this planet below 1.5 degrees. The science could not be clearer. And it seems to Vanuatu that international law may in fact be one of the last levers that we can pull to motivate some of these high-emitting states to keep their conduct in line with what is safe for a livable planet. International law, of course, is broad, and it is much broader than just the UNFCCC, just the Paris Agreement. This is certainly not the only treaty that we have that contains essential obligations to prevent climate harm and to protect human rights. So from our perspective, this advisory opinion from the world's highest court will draw what we hope is a clear line between what is an acceptable outcome of the UNFCCC negotiations and what is in fact a non-negotiable legal responsibility for all states. So in our view, climate action is not a mere matter of state discretion, but it is in fact an exacting requirement under international law that comes with enforceable consequences. So I should state from the outset that Vanuatu is unequivocally committed to the success of the multilateral climate negotiation processes. We have been negotiating in good faith for more than 30 years, and we very much desire to see the full and comprehensive implementation of the Paris Agreement. Our conclusion and the reason that we have initiated this process is that we feel the advisory opinion from the court will significantly support the negotiations, both in general, but also right now, in this present juncture that we find ourselves in, both in the negotiations, but also outside, with the horrific wars in the Ukraine and now the Middle East, and also a renewed and expanding emphasis on fossil fuel industries. The latest science couldn't be clearer. The NDCs, the nationally determined contributions that each state has made as part of their obligations to the Paris Agreement are far off track. They are going to take this planet well beyond 1.5 degrees, well beyond 2 degrees, and into an era of catastrophic loss and damage for all countries and all people. And so we have to bring as much pressure as possible to ensure that the existing NDCs are enhanced and that the ambition actually meets the scientific requirements. Of course, we also have to see finance ramped up so that those NDCs, particularly in developing countries or SIDS or LDCs, can be met. There are also, of course, areas within the UNFCCC negotiations which are absolutely fraught with controversy and dissent. For example, climate finance. Who pays? On what legal basis should it be provided? What are the modalities of providing that finance? And of course, as you know, loss and damage is still under negotiations after Vanuatu first called for finance for loss and damage more than 30 years ago in the early 1990s. It still hasn't been provided on an international scale. And we need this authoritatively clarified so that we can finally move forward in implementing our aspirations for a safe climate and a safe planet. There are other matters also, of course, in the UNFCCC and in the climate negotiations, which have only been marginally covered, but hold critical importance. For example, human rights. Human rights you will find only ambiguously introduced in the Paris Agreement in the preamble about states needing to uphold their obligations on human rights, but it's never actually been clarified about what those obligations are, nor has a COP decision ever been taken about implementing human rights implications on climate change. So we feel that the ICJ advisory opinion will finally be able to look at the wider context of the treaties and the conventions and the instruments like the human rights covenants or conventions, but also some of the legal developments that have happened outside the UNFCCC. For example, all of the incredible work that has been done by the Human Rights Council, which is significant, but it is very little permeated our climate negotiations spaces. Of course, if you've been following anything related to the UN Convention on Climate Change, you'll know that loss and damage finance is a huge topic. And in fact, it's undergoing quite a bit of work at the Transitional Committee to operationalize the fund and funding arrangements that we so desperately achieved at COP27 last year. But from Vanuatu's perspective, the discussions that are happening right now, literally this week and next week, in the Transitional Committee are very far from what is required when it comes to finance for loss and damage. We continue to hear this narrative about loss and damage finance being considered as charity or discretionary. There are proposals right now that to put the decision-making authority over finance for loss and damage in the hands of the rich developed countries, the historical emitters who in fact caused loss and damage in the first place, and minimize the voice of those most vulnerable countries who are actually experiencing the worst effects of loss and damage. So these are unacceptable outcomes of negotiations, which we feel this advisory opinion will directly influence. And of course, under international law, which is slightly uncomfortable for many countries, there is the additional obligation that when a state has breached its obligations under international law by a specific act or the omission of a specific act, there is in fact recourse. There is in fact remedy for those who have been injured, those who have experienced this kind of loss and damage. And so under international law, this is often referred to as making full reparations. And there are different ways that international law stipulates that reparations can be made. Of course, there is the possibility for restitution, that is the state committing the wrongful act, bringing back the injured to the situation of before that act was committed. That, of course, would be very difficult for loss and damage. I mean, when you consider just in the Vanuatu context, our coral reefs, which have been absolutely devastated irreversibly by coral bleaching and by ocean acidification, or if you consider villages which have been completely buried entirely by landslides, their water sources, their gardens. I mean, these are situations in which restitution would be very difficult. Under international law, as part of reparations, you could also have, of course, satisfaction, which would mean that those states responsible for the wrongful acts of climate change would say sorry and recognize the issues that they had caused. But again, this might not get us to where we need to be. But one very important aspect of full reparations, which is directly relevant, of course, to loss and damage, is the possibility for compensation. And under international law, states' responsibility for internationally wrongful acts or omissions would be to cover any financially accessible damage. So we're expecting that the advice on this second part of the question, which Autumn talked us through about the legal consequences for states would actually transform the discourse and the discussions around loss and damage, making it much clearer on, for example, the sources of climate finance, the modalities for channeling that finance, the flows to those who have been and continue to be detrimentally harmed by these acts or emissions. So in summary, I would say that whether you are particularly interested in seeing the full and comprehensive and effective implementation of the Paris Agreement, whether you are an individual or a state that wants to see revised and enhanced NDCs that keep this planet below the 1.5 degree threshold, whether your interest is in ensuring that human rights become enshrined in the climate negotiations and are fully considered when we take action on climate change, including the rights for future generations and ensuring intergenerational equity, or whether you are looking for this kind of constructive clarification on these divisive and deadlocked issues like finance for loss and damage, then this ICJ pathway is for you. And we need to make sure that every state who has something to say, not just Vanuatu, not just the 18 countries that develop this question to the court, but every state that wants to say something must be given an opportunity to make a submission by the deadline of the 22nd of January next year, just a few months from now, and participate fully and wholly in this process. So I would encourage you from the government of Vanuatu, especially if you are a state from the global south who may not have the full capacity to prepare a submission, or you haven't yet thought about how you would engage in this process, I would encourage you to reach out to Vanuatu or to SPC or to any of the other organizations that are here now to provide support to you so that we can identify the resources that you may need to make sure that your voice is heard at the world's highest court and make a difference to protect finally this planet and see more ambitious climate action. So with that, thank you very much. And I look forward to any questions you have.
Thanks so much, Chris, for those remarks. We'll now turn it over to Rose, who will be talking about Tonga's experience preparing submissions for the ICJ.
Okay, thank you very much, Autumn, and Malolele, everyone. Thank you, SPC, for arranging this important webinar, which is the first of its kind, and one I believe that is important for us in the region. And my presentation today is just focused on Tonga's journey to the International Court of Justice. My talk will just cover 3 main points. And the first is why are we making a submission? The second is where are we at? And third, where to from now? And so in answering the first question, there are 3 main points which I wanted to talk about. And the first is basically Tonga's vulnerability. And Tonga, like many of the Pacific Island countries, are at the forefront of climate change impacts, from extreme weather events to sea level rise. And most importantly, it is an aggravating challenge to the multifaceted problems we encounter as a small island developing state. And for us living in the Pacific, we ourselves have lived through these extreme weather events. We've experienced loss of life, properties, and livelihoods. And we know the ongoing struggles in building something which lasts generations, not only just ours, but for those who are to come in the future. But thanks to our faith, our people, our culture, we have been resilient through it all. The second point is that who better to answer the question? I was quite fortunate to meet Professor Chaloka Beyani of Zambia, who reminded us that who better to answer the questions that are posed before the International Court of Justice than those who are small island developing states or vulnerable peoples. And it's really important for us to have our say in this by making submissions to the International Court of Justice. And third, and most importantly, it is a plea which originates from our youth, current youth, and future leaders of the Pacific region. In my view, it is our duty to act and advocate for their interests, and failure to do so would be a neglect on our part, on our youth and future generations to come. And so we have these projections on what lies ahead, and it is our responsibility to advocate and obtain the best that we can in every single forum, whether it be UNFCCC, ICJ, and other multilateral forums for our country, our youth, and our future generations. The second point is part I wanted to cover is where are we at? So for Tonga, the Honourable Prime Minister and Government's Cabinet endorsed that we establish a Tonga core team to focus on Tonga's submission to the International Court of Justice. And this team is comprised of the Attorney General's Office, the Department of Climate Change, and Foreign Ministry. And under this Tonga core team, we have an Attorney General's working group, office working group, and it's a group of young, brilliant lawyers and law students. We also have the Vice President of PICTs, who are all undertaking research collaboratively and taking a jab at Tonga's submission. And we're grateful for the Vanuatu team and the template which you had shared with the Pacific Island countries. The other point is external lawyers. We are working on confirming external lawyers who can assist the team in ensuring that our work on the submission is meets the ICJ standard. The other point is mobilizing financial resources. For Tonga, additional financial support is needed, particularly when it comes to fees of external lawyers and any funding arrangements for travels or additional work that we would actually have to work on. And finally, for this particular point, we are keeping track of discussions at the regional level. And this is the SPC informal working group has been instrumental in this. And it has allowed us to access regional experts and also to ensure that our submissions are aligned with any regional submissions made by, for instance, the Forum on Sea Level Rise and also the Melanesian Spearhead Group. And the final point I wanted to cover is where to from now. We have a set timeline for completion and we are working towards it. We're hoping to complete the team that is Tonga counterpart plus external lawyers and any external support by the third week of October this year. We're hoping that we will have at least a zero draft by November. And then we have the period of time from November to January to submit it to the Tonga core team for approval and then onwards to Cabinet before we submit it to the International Court of Justice before the time limit of 22nd January 2024. And so January 2024, in our view, is the midpoint in Tonga's journey to the ICJ. Then we will work on our timeline once we hit January 2024 and once we've submitted our submission. I must say it's not an easy task. It is absolutely new for us. And this is undertaken in addition to other work that we have. But there's a passion and a drive to actually get this through. And again, it is for our youth and for future generations. It's important that we actually make a submission. And so before I conclude, I just want to acknowledge the hard work of the SPC team, Vanuatu team, and all the external support in this collaboration, and even this webinar, which we're finding quite helpful in the work that we're undertaking. And we look forward in working together towards our journey to the ICJ and making sure that the advisory opinion issued is something that works in our favor and our interests. Thank you.
Thanks so much, Rose. We can now move on to the Q&A. So maybe all of the panelists can turn on their cameras, and we've already got some questions that have come in. So we can just get into it, I suppose. So the first question that we have is about the law of state responsibility, whether there is any consideration of the obligation of states to its own citizens in the draft articles or elsewhere. And I can just maybe jump in and give a quick answer to this, and then others can feel free to chime in. But the draft articles on state responsibility is really talking about internationally wrongful acts. So that's sort of the conduct of one state that harms another state. However, if we are talking about sort of the obligations that states have to their own citizens, that really gets into the human rights questions. The states, I should say, individuals like states have, in accordance with their human rights, they also have a right, a guarantee of sort of cessation of violation and remedy for harm if their rights are violated. And in the international human rights treaties, the ICCPR and the ICESCR, states that have ratified these treaties, which are, again, virtually all states, in doing so, they've taken on obligations to uphold, protect, and effectuate the human rights of their citizens. So when we're talking about these sort of individual rights, really, this is sort of the human rights dimension of the question. I don't know if anyone else wants to chime in. Otherwise, we can go to the next question, which is for Mamadou. Or Mamadou, did you want to chime in for the first one?
Yes, I would say in general, there is a distinction that we make between primary norms and secondary norms. And the primary norms are those norms which define standard of conduct, rights and obligation at the substantive level. So human rights tend to interfere in that level. They give rights to individuals, they impose obligations onto state. Now, the ILC articles that this person referred to deal with all kinds of primary norms. What are the consequences that attach to their violations? So if a state breaches its human rights obligations, what are the consequences? Cessation, reparation, and all the other consequences are governed under the ILC articles on responsibility. So the way that the question is raised seems to conflate the two levels, to say that it is the ILC articles which will provide the obligation of states with respect to human rights. Those obligations exist in the treaties that Autumn was just mentioning, the ICCPR, the Convention Against Torture, the ICESCR. So, and those obligations exist there, but the ILC articles will define all the consequences that attach to their breach and violation.
Yes, thank you for that clarification. The next question is also for you, Mamadou. So the question is basically about this press release that came out in which the ICJ outlined that all states and organizations are invited to submit written statements and that are invited to make an oral statement, whether or not they have participated in the written phase. So the question is, does this mean that those countries and international organizations that were originally invited can still take part in the oral proceedings, even if they did not submit a written proceeding submit a written submission? And what's the typical practice around this?
Perhaps send me the link to the press release, because that's the best way not to misinterpret it if we have it in front of us. If we don't have it in front of us, I will just try to offer some general comments as to the procedure. As to the procedure, the idea is that all states have automatically the right to participate in both written statement and in oral statement. That's the principle. If you are a state, You are a member of the United Nations. This is your court. There is a legal question which is asked to your court. You have the right to come and tell the court how it has to answer those questions. If you are an international organization, you don't have an automatic right to present your arguments to the court. You will be authorized to do so if the court deems that you have the information necessary, helpful to the court's work. Now, initially, the idea was that it was the court, because 1945, you did not have too many international organizations. It was easy for the court, based on the question that it receives, to see, okay, I should ask this, that, and that organization. Today, you have more than 1,000 or even more international organizations, and judges don't know all of them. So if you believe that you are an international organization which is capable of providing relevant information on the advisor opinion, you request from the court authorization to participate. You request from the court authorization to participate. So there is a practice which has nuanced the application of Article 66 of the statute. You don't wait for the court to give you a call, but you go to the court and ask whether, and tell the court, I believe that I have relevant information to provide to you with respect to the advisory proceeding, which is pending. And you explain a little bit. I prepared the request to intervention for the OACPS. So it's a 3-page document, but I believe that we did more than we had to, just to make sure that we were safe through. But it's a 1-page or 2 maximum document where you explain really what are the type of information you want to provide. You prove that your statute and your constitutive instrument allow you to do what you want to do, and you proceed. Now, what happens if you have not participated in the written phase and want to participate in the oral phase? For state, I know you can. States, you can. For international organization, I am not sure, because you see that there is always this distinction that the court makes between states and international organization. States, you can. It is your court. You are always free to come and tell whatever you want to the court. It will listen. But for international organization, the court needs always to determine that you are capable of providing relevant information to the court. So I can quickly check the second part of the question and refer to you. I got the press release, and therefore I will refer to you in 2 seconds. Yeah. So let's continue the conversation. I will pick up and then clarify that point. Yeah.
Okay, sounds great. So our next question is about the sort of second question around legal consequences. Do we anticipate resistance from the court in answering that second question and bringing up issues of causation? Is there a way to frame answers avoiding it? If anyone wants to give remarks, otherwise I can also speak. Okay, I mean, I guess just maybe 1 or 2 things to say. I mean, one thing is about the framing of legal consequences. This is a formulation of a question that has been put to the ICJ several times in the past in requests for advisory opinions. For example, legal consequences of the separation of Chagos from Mauritius, and legal consequences of the construction of a wall in occupied Palestinian territory. So in this sense, it's sort of like a well understood formulation of a question for the ICJ, and it's sort of somewhat specific in terms of understanding what the court is asked to opine on, and there's not a lot of ambiguity there. It's sort of like, again, if a state has breached an obligation, then what are the consequences in terms of what does it have to do to remedy that situation? On the issue of causation, that definitely is sort of a tricky question. I mean, we are commissioning an expert report on the issue of attribution science, which is this field of linking greenhouse gas emissions to climate forcings and to harm that results from those climate forcings. So for example, greenhouse gas emissions to extreme weather events and the harm that has stemmed from these extreme weather events. So that's definitely sort of an area that it's important to make strong arguments about. But yeah, it definitely is a tricky issue. So I guess those are my comments. I don't know if anyone else wants to jump in.
Maybe very quickly, I'll just say that Vanuatu, throughout this process, has been clear that we do not intend to name, blame, or shame any specific state for actions. And our intention, of course, is to demonstrate that there are obligations beyond the Paris Agreement and that obligations have generally been breached and therefore consequences are available. Without getting into specifying any particular damages or expected consequences for the Vanuatu case in particular. So I think in generalities, it may be easier to avoid the intricacies of causation. That may be something for a later litigation exercise, but this process is very much generally about clarifying international law.
Yeah, thank you, Chris. That's a really important point to make. You know, this isn't a contentious case that is being brought against any particular states. It's just asking for sort of a general interpretation of legal principles in this context. Let's see about our next question. Oh, yeah, go ahead.
Yes, now that I got to read the opinion, the press release makes it clear that all states and organizations that are invited to submit written statement will be invited to make an oral statement at the public sitting held on the court, held at the date fixed by the court, irrespective of whether they have participated in the written phase. So both states, I was sure, international organization also, but they have to be accepted by the court as having relevant information to provide. Now, I would just jump in on the question you were just discussing while I was checking the notes. Question 2 is difficult, and I think that we will get a lot of pushback for it will get a lot of pushback from Western countries, those countries that have polluted the most and are mainly the cause of climate change. Let's put it that way, straight on the table. Yes, they are really responsible for it. The reason why it will raise an issue is that advisory opinions are not supposed to be contentious cases. So if we frame question 2 as identifying specific states, showing their contribution to climate change and asking from them specific payment, we may be changing the nature of the proceedings from an advisory proceeding to a contentious proceeding. And that is something the court doesn't like. We all understand that, yes, there are advisory proceedings where you could see the contentious case just behind it, but to the extent that the court can keep it to an advisory proceeding, it prefers it. It prefers, therefore, not making the clear finding of responsibility on specific states or with respect to specific convention. And there is something practical. There is a practical reason for it. The court will not have all the cases before it. Each state, for instance, Germany, will not be able to provide us with all the evidence on Germany's contribution to climate change. It will not be able to show what is attributable to it and what is not attributable to it at this stage of the proceeding. So therefore, the contentious proceeding, the advisory proceedings are not really the best place to do this kind of contentious determination of responsibility. Nevertheless, the general principle can be clarified. And the first of such principle is that if you violate the rights of other states with respect to climate change, you have a duty to cease the violation. That is one thing. Secondly, you have to take measures in order to mitigate the consequences of the violation. Thirdly, you have to pay compensation. We are not naming anyone, but those obligations, the clarification already of the secondary consequences attaching the breach, I believe is extremely important. As was mentioned a couple of minutes ago, it will strengthen the negotiation stage. If you think about, for instance, reparation, yes, people are saying that we have to do it just out of our goodwill. But that cannot be the case, because if today one of our countries decide not to respect an investment treaty, no one would say that the compensation that we have to pay for expropriation, we are doing it out of our goodwill. But this is just one person. Here we are talking about billions of persons. Why would it be that a damage caused to billions of persons would be less compensable than the damage caused to one single person? So what we want to really do is to reassert the application of the general rules of state responsibility and their consequences to the issue of climate change. And I believe that that's already, if the court was able to follow us on these general principles, that would be more than enough for this stage of the proceedings, because nothing excludes that after the advisory opinion, there is a contentious proceeding against, let's say, the top 3 or the top 5 polluters for their part of the in climate change. Thank you.
Thank you all for your comments. Our next question is about the preparation of submissions, and specifically what external legal support will SIDS require in preparation of their submissions. Maybe Rose, you could talk a little bit about your experience with this.
Thank you very much, Autumn. I guess it'll vary from country to country. For those of us, like for instance, Tonga, if being new to this whole proceeding, I think it's important that we have at least external lawyers who can assist. Some would be from the submission all up the way until representation, replies, etc. For those of us who have budget constraints, what we're trying to do is at least compile something to the best that we can, and then where we can obtain some sort of pro bono legal service, we think it's really important, particularly those with ICJ appearance experience, to really guide us when it comes to, how are we framing the argument correctly, like, presenting it well, is it up to that standard which is required by the International Court of Justice. So that sort of legal guidance is important for I'd say newbies like Tonga. That's just my comments on this. Thank you.
Thank you. If anyone else wants to jump in.
Just one thing. Based on my experience at the ICJ, I promise you that you should not be worried about the quality of your argument before the court. I always tell people that someone who can make a decent argument before the court is an LLM student. It's just a master student. Legal arguments, I understand that this is our trade and our bread and butter, but it's not that difficult, because often we have made of it such a mystery that eventually we are afraid of appearing before the court. A sovereign state has the right to say everything to the court. What it believes is law, and that's more than enough. That's really more than enough. Of course, getting experienced counsel may help you marshal, especially the entire procedure, to make sure that you hit the deadline. That's not easy. It's really, really not easy. The 22nd of January may be far away, but if you are not used to preparing written submissions in a team, trust me that many things can go wrong, even starting from having a consistent citation framework. Yes, everyone writes his thing, and then 2 days before the deadline, you realize that, oh, we are not having the same citation style. So someone has to remain awake in order to do these kind of things. So getting experienced counsel is important on that aspect, but I will really encourage all the states and international organizations here, if you take external counsel, please closely supervise. Closely supervise what they put there. Don't just give it to them and wash your hands. No, because they don't know your policy goals necessarily. They may have a sense of them, but they don't know it. I give you a concrete example. In the Kosovo advisory opinion, there was one African country that supported secession. It's just strange because no African country supports secession. Each African country is made of at least 60 tribes and ethnic groups. So if you accept secession, it means that tomorrow morning you are no longer a country. But there was one African country which came before the court and defended secession. And do you know what was the reason? They hired external counsel and did not closely supervise. So later it became the joke that, okay, why is it that that country was supporting secession when we know that no African country really would ever support secession? So I would say exercise a close control on the memorial, the written statement, making sure that it really fits your policy goal. But don't be worried about the quality of your argument. Honestly, it's no, not two, but 4 or 5 very good LLM students can write to the court the argument that are sufficiently convincing for it's like your domestic courts. Even a domestic lawyer can write the real argument before the court. Perhaps the person won't remember on the top of their head all the case law. That I agree, because these are things, those who are working with it really know it more. But honestly, it's not such a difficult task. Yeah.
Thank you. Yes, that's such a good point.
Thank you, Professor. Now I feel empowered. But we definitely have a couple of LLM students in our working group. So thank you very much for the word of encouragement.
And maybe I'll jump in here to say that many of our partners have requested some support, and the support is available. So if there are countries listening that do want a little bit of expert advice or guidance, it is there. It's available. It's free. So please do take advantage. Don't feel that just because you don't have external legal support that you shouldn't be making this submission. Yeah, absolutely. As Mamadou said, take this opportunity. It shouldn't be missed. And if you want that help, it is available right now.
Great. So we just conscious of time, maybe we'll just do one last question, which is another question on procedure. It's sort of a two-pronged question, but the first is whether there's any precedent or practice for a submission that is focused on basically furnishing information, textual, contextual, and factual information, rather than providing written legal arguments. So that's the first question. And then the second question, which is sort of following up on the procedural question that was already asked, You know, there was a question of whether a state or international organization can participate in oral proceedings if they didn't provide a written submission. So this is sort of a similar question, which is if a state doesn't provide written submissions initially, are they still able to participate in the second round, that is commenting on the written submissions of other states? So maybe Mamadou, if you want to start us off.
I would say the first one, commenting on the written submission of other states, I don't think that you will be allowed to do that. You won't be the only sniper in the room shooting down others without submitting your own memorial, but you would be able to participate if there is a second phase of, if there is oral hearing after the first phase of written submission, you are allowed to participate in that oral phase. But in general, it is those who have made the submitted written statement that will be allowed to comment on the submissions made by other states. It's just a matter of equality of arms, making sure that the parties are on the same point. You had a first part to the question and I had a clear answer to it, but now it's escaping my mind. Just the first part.
Yes, it's about whether there's precedent for providing a written submission that's more factual, like technical information.
Yes. I have to tell you that when you go on the website of the court, you have a tab on advisory proceedings, and there you can see what kind of submissions other states have made in past advisory proceeding. Trust me that there are submissions of 3 pages, of 2 pages, of 7 pages, of 200 pages. That's why I'm telling you, don't mystify what is being required. And when I say that, don't believe that it was Burkina Faso, Mali, and Niger who made the 3 pages submission. France's submission in Kosovo or in the Chagos advisory opinion was 7 pages. That was it, 7 pages at all. It is, I believe that the strongest submissions are the submissions who start from clearly articulating the country's policy goals. I am a mountainous country. This is what climate change is doing with respect to mountainous countries. This is how I interpret the obligation. Here are the consequences, and I'm done. And I'm done. I am Burkina Faso. I'm preparing the submissions for my own country, Burkina Faso. We are a semi-desertic country. Climate change has led to desertification, rarefication of resources, which has triggered terrorism. So we want to make the point that there is a link between climate change, desertification, maintenance of peace and security, and this has triggered 2 military coups last year, and instability of political institutions. So I'm coming from that perspective, and here are my answers to your 2 questions. So don't really think that it is, it's not a PhD thesis. It's really not a PhD thesis if that's supposed to be the most difficult legal exercise, but it's not a PhD thesis. It's just expressing your answer to the 2 questions from your standpoint. Because what you want the court to be able to do, it is to look at the questions from the standpoint of all the international community and not to have any blind spot in this respect. So you can come before the court and tell the court, look, what I wanted to tell you today was climate change is real. And here are my facts. And you are done. You have contributed, you have provided relevant information to the court. So you are not obliged really to think about the most comprehensive type of answer covering all hypotheses and scenarios.
Thank you. Great point. I'm conscious of time. We're just approaching the end. So maybe any last remarks from the panelists? Chris, I see you have your hand up, so.
Thank you. I wanted to bring up the point of those organizations that may not have legal standing to make a submission on their own. And I'm particularly referencing some of the incredible civil society who have been with us from the very beginning of this journey. If there is the possibility that civil society are preparing submissions, it's always a realistic option that you approach a state that may be favorable or considerate of your views and request that they take on board your submissions either in their formal submission itself, or in the case of Vanuatu, we've made a commitment to take on board civil society submissions as annexes to our own submission. So if this is something that you're interested in, please do consider that there are ways to have civil society, non-state, non-government perspectives included in the official submissions of governments. Otherwise, of course, you can submit. It won't be a part of the formal proceedings, but of course it will be made available to justices. But in the case of those who have been doing outstanding legal analysis, the Pacific Island Students Fighting Climate Change, the World Youth for Climate Justice, Vanuatu very much looks forward to having their perspectives be a part of the annexes to our submission, just to let that be known more publicly.
Great, thanks so much for sharing that. It's super important to get that message out. I think we're basically at time, so just thank you so much to all of our panelists and speakers for sharing your time and knowledge today. I'm sure I learned a lot, we all learned a lot. And yes, thank you everyone for your attendance as well. I suppose unless there are any other last remarks, we can close it there. Joanna, I don't know if you want to jump in.
I just want to do a quick announcement. Of course, thank you to all the panelists. I think, I'm really glad that we have this fully recorded, and we will definitely continue to share these messages really globally. It's quite important. We just wanted you to know that our webinar series, this is the first one that kicked us all off. Our next set one will be on children's rights and intergenerational equity that is co-sponsored by Pacific Island Students Fighting for Climate Change, UNICEF, 350.org, PCAN, a lot of those groups. So that's going to be a really wonderful next webinar to look at. We also have a list of things that the Pacific has put forward that we would like to do webinars on, ranging from gender equality and displacement, persons with disabilities, looking deeper into fisheries, how to use science in climate litigation, things like this. And we really, as SBC, want to open it up to the region and to folks. So if this is something that is of interest to you, that you would like to take part of or like to be on a panel for, we just want you to feel empowered to come and reach us, and we will help to set another one of these up. Because it really is so important that we're starting these conversations now. I've just dropped my email into the chat box. Feel free to get in touch. And with that, thank you all so much for being here. And we really hope that this was a helpful hour and a half. Good for us. We did well in keeping it into that time. Thank you all so much. And we look forward to continuing the conversation. Take care.
Thank you, everyone.